Seniors, listen up. The Supreme Court just delivered an 8-1 ruling that changes everything for older Americans. Here is the truth they are not telling you. Stop scrolling right now, because what I am about to tell you could put thousands of dollars back into your pocket, and most American seniors will never even know it happened. The United States Supreme Court just issued one of the most consequential decisions for older Americans in over a generation, an 8-1 ruling that upholds and expands the full framework of the Elder Care Protection Act, sweeping bipartisan legislation that was already working its way through implementation across the country. This ruling does not just preserve the law, it strengthens it. It closes loopholes that industry lobbyists were counting on. It accelerates timelines that pharmaceutical companies were hoping to delay. And it establishes constitutional protections for senior benefits that no future Congress can quietly strip away without facing a direct legal challenge. If you are over 60, if you are caring for an aging parent, if you are approaching retirement, or if you are already living on Social Security and Medicare, this ruling directly impacts your wallet, your health, your home, and your future. And the implications are enormous in ways that most people have not fully processed yet. But here is the part that should make you furious. The mainstream media is barely covering the details. They gave you the headline: Supreme Court upholds elder care law 8-1. And then they moved on to the next story. Meanwhile, millions of seniors across America have absolutely no idea what is now constitutionally protected, what they are legally entitled to, or, and this is the critical part, what deadlines they could still miss if they do not act fast. Because here is what the Supreme Court ruling did not do. It did not automatically enroll you in every benefit. It did not send a check to your mailbox. It did not call your insurance company. It upheld and accelerated a framework of protections and benefits. But many of those benefits still require you to apply. Some require you to update your records. Some have enrollment windows. And if you miss those windows, you lose access until the next cycle opens. So today, we are breaking it all down. Every major area the ruling touches in plain English. No legal jargon, no political spin, just the real practical dollars and cents truth about what just changed for American retirees and their families because of this historic Supreme Court decision. Grab a pen, take notes, and share this with every senior you love. Let us get into it. First, let us talk about where this ruling came from and why it matters so much more than a typical legislative update. For decades, seniors in this country have been quietly fighting a system that was not built with them in mind. Prescription drug prices that defied logic, nursing homes operating with virtually zero accountability, Social Security adjustments that fell further behind the real cost of living year after year, a tidal wave of elder financial fraud that has stolen the life savings of millions of hardworking retirees, and a legal landscape where the protections that did exist were constantly being challenged by industries with deep pockets and armies of lawyers. These were not small inconveniences. These were full-blown crises playing out quietly inside millions of American households. And for too long, the legal system provided inconsistent protection, while industry groups challenged every new protection in court, hoping to delay, water down, or eliminate benefits that seniors had fought hard to secure. The 8-1 Supreme Court ruling changes that equation permanently. When the Supreme Court speaks at this level of consensus, it does not just decide a case. It sets constitutional precedent that shapes every lower court decision, every regulatory action, and every legislative attempt to modify these protections going forward. The one dissenting justice wrote narrowly on procedural grounds, not on the substance of senior protections. The 8-justice majority opinion was sweeping, clear, and unambiguous in its protections for older Americans. This ruling is one of the most significant legal events for seniors in modern American history, and the reason we need to talk about it in detail is because the news cycle moves fast. But the details, the real practical changes, are where the real money and real protection live for you and your family. Let us start with the change that is already making pharmaceutical companies panic: prescription drug pricing reform. If you are on Medicare, this is something you have been waiting your entire retirement to hear. For years, Medicare, the largest purchaser of prescription drugs in the United States, was legally prohibited from negotiating drug prices directly with pharmaceutical companies. Read that again. The biggest buyer of medications in America was banned by law from using its size and leverage to bring prices down. Private insurers could negotiate. The Department of Veterans Affairs could negotiate. But Medicare, which now covers over 67 million Americans, could not. The result was that seniors in the United States were paying some of the highest prescription drug prices in the entire world for the exact same medications that people in Canada, Germany, and Japan were getting for a fraction of the cost. Drug pricing reform changed that, and what the Supreme Court's 8-1 ruling just did was slam the door on every pending legal challenge that pharmaceutical companies had filed, trying to gut the negotiation provisions before they could fully take effect. There were 11 separate active legal challenges to Medicare drug price negotiation working through federal courts. With this Supreme Court ruling, those challenges are effectively dead. Not delayed, not sent back for reconsideration, dead. In practical terms, if you are currently spending $200, $300, or even $500 a month on medications for diabetes, heart disease, arthritis, blood pressure, or cholesterol, there is a real chance those costs are about to drop, not someday in the distant future, on a rolling schedule that is now constitutionally protected and legally accelerated. The ruling also upholds the annual out-of-pocket drug cost cap for Medicare beneficiaries. That means there is now a constitutionally protected legal ceiling on what you will ever have to pay in a single year for medications. No matter how many prescriptions you fill, no matter how expensive the drugs are, for millions of seniors who have been forced to choose between filling a prescription and buying groceries, this is not a small change. This is life-changing. What do you need to do? Contact your Medicare Part D plan and confirm your out-of-pocket maximum for 2026. If you have been hesitating to fill a prescription because of cost, call your plan administrator and ask how the negotiated price changes affect your specific medications. You may be paying more than you need to right now without knowing it. Now, let us talk about Social Security, because this is the section that gets people fired up, and rightfully so. Social Security has been the financial backbone of American retirement since 1935. It was designed as a sacred promise. You work, you contribute, and when your working years are done, the system takes care of you. But over time, that promise started feeling shaky. Cost of living adjustments, known as COLA, are supposed to protect your benefits from inflation. Every year, the Social Security Administration looks at inflation data and adjusts your monthly payment. But here's the dirty secret that seniors have been shouting about for years. The inflation formula they use does not reflect how seniors actually spend money. The standard formula tracks the spending habits of urban wage earners: gasoline, electronics, work expenses. But seniors spend differently. You spend more on healthcare, prescription drugs, in-home care, and utilities. Categories that rise in price faster than almost anything else in the economy. The result has been that seniors were technically getting inflation adjustments, but falling further behind in purchasing power every single year. The Elder Care Protection Act pushed for the adoption of an inflation index specifically designed to track senior spending patterns. The pharmaceutical and insurance industries challenged this provision in court, arguing it exceeded congressional authority. The Supreme Court, in an 8-1 decision, ruled that it does not. The Senior-Specific Inflation Index is constitutionally sound and legally required to be implemented. Translation: your annual Social Security adjustment will finally start reflecting what your life actually costs. Over time, this can mean hundreds of extra dollars per year in your pocket. When you are on a fixed income, a more accurate inflation adjustment year after year compounds into something massive. We are talking about thousands of dollars over the course of a decade in additional benefits that you would not have received under the old formula. The ruling also upholds the provisions that strengthen Social Security's long-term funding by adjusting the payroll tax cap so higher-income earners contribute more, stabilizing the system for everyone today, for your children and for your grandchildren. What do you need to do? Log into your My Social Security account at ssa.gov and verify your benefit statement reflects current COLA adjustments. If you believe there is a discrepancy, contact the Social Security Administration directly to request a review. Now let us move on to nursing home reform, because this part of the ruling does not get nearly enough attention, and it is absolutely critical. The unfortunate reality is that nursing home abuse and neglect in America has been a persistent, devastating problem. Federal reports have repeatedly shown that a shocking percentage of nursing homes have been cited for serious violations: inadequate staffing, poor sanitation, medication errors, and in the worst cases, outright physical and emotional abuse. The nursing home industry fought back against new staffing mandates and penalty structures through multiple lawsuits. They argued the minimum caregiver to resident ratio requirements were administratively overreaching and economically burdensome. The Supreme Court, in its 8-1 ruling, found overwhelmingly in favor of the senior protections. Under the now constitutionally confirmed provisions, nursing homes that receive Medicare or Medicaid funding, which is nearly all of them, are subject to much stricter staffing requirements. The new rules mandate minimum caregiver to resident ratios that are now legally enforceable. Your mother or your father will have a real trained human being available when they need help, not a single overworked aide trying to manage an entire hallway alone. Penalties for safety violations are being dramatically enforced. In the past, fines were so small that many facilities treated them as a cost of doing business. That ends now. Fines are increasing, and repeat offenders face the possibility of losing their Medicare and Medicaid funding entirely. For most facilities, that is a financial death sentence. There are also transparency requirements that are now fully enforced following the Supreme Court ruling. Nursing homes must make their inspection reports, staffing data, and violation histories publicly and easily accessible. That means when you research a facility for yourself or a loved one, you will see the real story, not just the glossy brochure they hand you at the front desk. What do you need to do? If you have a family member in a nursing home or care facility right now, visit the official Medicare Nursing Home Comparison Tool at medicare.gov to see their updated inspection reports and staffing data. If you have concerns about the facility your loved one is in, you now have stronger legal grounds than ever before to demand accountability. Now, let us talk about something that does not get the attention it deserves. Elder financial fraud. This is a silent epidemic robbing American seniors of tens of billions of dollars every single year. The schemes are everywhere. Fake IRS phone calls, Medicare fraud, investment scams, romance scams targeting lonely widows and widowers, contractors who take a deposit and disappear, and tragically even family members or caregivers exploiting access to a senior's finances. The industry groups representing financial institutions had challenged certain mandatory reporting requirements in the fraud protection provisions, arguing they imposed excessive compliance burdens. The Supreme Court rejected that argument entirely. 8 justices agreed that the government's interest in protecting older Americans from financial exploitation justifies the reporting and coordination requirements. That means banks and credit unions are now legally required to flag suspicious transactions on senior accounts and have clear protocols for reporting potential exploitation. A sudden large withdrawal, multiple wire transfers to unfamiliar accounts, a new name suddenly added to an elderly customer's account. These are red flags, and financial institutions now have both the legal mandate and the liability protection to act on them. The ruling also upholds dedicated federal funding for elder fraud prevention and prosecution. That means more federal investigators specifically trained to pursue these cases, more resources for victim recovery, and stronger coordination between federal agencies, state law enforcement, and financial institutions. There is also significant funding for public education campaigns aimed at seniors, because the best defense against fraud is knowledge. When you know the tactics that scammers use, you become almost impossible to fool. What do you need to do? Contact your bank or credit union and ask what elder financial protection protocols they now have in place. Set up account alerts so you are notified of any significant transaction, and write down the official phone number for the National Elder Fraud Hotline, which is 1-833-FRAUD-11, and keep it somewhere accessible. Let us talk about housing and aging in place. For most seniors, your home is your largest asset and the heart of your life. The ability to age in place, to grow older, surrounded by your memories in your community, is something nearly everyone wants. But our homes were not designed for the later stages of life. Stairs become dangerous. Bathrooms without grabbers become accident zones. Narrow doorways become barriers to independence. And modifications can cost thousands of dollars that fixed-income seniors simply do not have. Home modification assistance programs were challenged in court on funding mechanism grounds. The Supreme Court upheld the full funding and implementation structure, meaning seniors across the country can now access these programs without the uncertainty that had been hanging over them. Eligible seniors can access financial help to install ramps, widen doorways, add walk-in showers, improve lighting, and make kitchens accessible. These are not luxury renovations. These are the modifications that let you stay safe, independent, and out of a care facility. When you consider what nursing home care costs, keeping seniors safely at home through modest modifications is not just compassionate, it is economically rational. The ruling also upholds major investment in affordable senior housing, communities designed with accessibility, health care access, and social connection in mind. Why does this matter so much? Because chronic loneliness in older adults has been shown to be as damaging to your health as smoking 15 cigarettes a day. That is not exaggeration. That is documented research from major health institutions. The social infrastructure of senior housing matters as much as the physical infrastructure. What do you need to do? Contact your local area agency on aging, which you can find through eldercare.acl.gov, to ask about home modification assistance programs available in your specific area. These agencies can connect you with both federally funded programs and state-level resources that may be available to you. Now let us address something that has been chronically underfunded and underacknowledged: mental health access for seniors. The Supreme Court ruling upholds major provisions expanding access to mental health services for seniors on Medicare. Right now, accessing mental health care through Medicare is complicated, expensive, and limited. Many therapists and counselors do not accept Medicare patients because reimbursement rates have historically been too low to make it financially viable. The legal challenges to improve mental health reimbursement rates came primarily from managed care organizations that argued the rate structures would drive up plan costs. The Supreme Court found those arguments insufficient. The mental health expansion provisions are upheld in full. That means seniors in rural areas, seniors with mobility issues, seniors who have been quietly suffering with grief, anxiety, depression, or the fear of losing independence now have access to telehealth mental health services that were not practically accessible before. Grief, loss, chronic pain, fear of dependency. These are real burdens that millions of older Americans carry every single day in silence. Help is now becoming accessible in ways it has never been before. What do you need to do? Ask your Medicare plan about mental health telehealth coverage options. You may be entitled to counseling services that your plan is not proactively telling you about. Let us talk about caregiver support, because this affects tens of millions of American families and almost never gets the attention it deserves. There are an estimated 53 million unpaid family caregivers in the United States right now. Sons, daughters, spouses, siblings, people who have taken on the enormous responsibility of caring for an aging loved one while also working, raising children, and managing their own health. The toll is staggering. Caregiver burnout is real. Depression among caregivers is extraordinarily common, and historically, these heroes received almost zero financial support, no meaningful training, and no public recognition. The caregiver tax credit provisions of the Elder Care Protection Act had been challenged on tax code modification grounds. The Supreme Court upheld the provisions. Family caregivers can now claim meaningful tax credits for documented care expenses. There is also funding for caregiver training programs and expanded respite care options so caregivers can take breaks without guilt or financial penalty. A rested trained caregiver provides better care. When caregivers burn out, seniors suffer. When caregivers have support, the entire family is better off. This is a change that reaches into millions of homes across America in ways that the headlines simply do not capture. What do you need to do? If you are a family caregiver, consult with a tax professional about the caregiver tax credits that now apply to your situation. Keep receipts and documentation for all care-related expenses because the documentation requirements for claiming these credits are specific, and you want to be prepared. Now, let us address the Medicare expansion area that has been the source of fierce debate for years: dental, vision, and hearing. Original Medicare does not cover routine dental care, eye exams, or hearing aids. This gap has always been glaring because untreated gum disease is directly linked to heart disease and dementia. Vision problems lead to falls, which are one of the leading causes of death in older adults, and hearing loss is one of the strongest risk factors for cognitive decline. These are not vanity services. They are fundamental healthcare needs that have been excluded from Medicare coverage in ways that simply do not make clinical or economic sense. The dental, vision, and hearing provisions in the Elder Care Protection Act faced legal challenges from provider groups and insurance industry representatives, arguing implementation timelines were unworkable. The Supreme Court rejected those arguments. The implementation structure is upheld, and the accelerated timeline is legally binding. New subsidies will help Medicare beneficiaries afford hearing aids, which routinely cost between $3,000 and $7,000 out of pocket. Pilot programs expanding dental care access through federally qualified health centers are now moving forward with full legal protection, and funding for vision services through community health programs is increasing. This is not everything that advocates wanted, but it is a constitutionally confirmed major step in the right direction. And with Supreme Court precedent now established, future expansions have a clearer legal path than they ever had before. What do you need to do? Contact your Medicare plan and ask specifically about dental, vision, and hearing benefit enhancements for 2026 and beyond. Additionally, search for federally qualified health centers in your area through hrsa.gov, as these facilities often provide dental services on a sliding scale for eligible seniors. Now, here is the part you absolutely cannot afford to skip, because everything I have told you until this point is only valuable if you actually act on it. Not every benefit upheld by this Supreme Court ruling is automatic. Let me say that again. The Supreme Court ruling confirms these protections exist and are legally enforceable. It does not automatically enroll you in them. It does not send a check to your mailbox. The ruling is the legal foundation. You still have to do the building. Some of these benefits require an application. Some require you to update your information with Medicare or Social Security. Some have enrollment windows. And if you miss those windows, you lose access until the next cycle opens. The senior who takes action in the next 30 days is in a fundamentally different position than the senior who watches this video, says, "That is interesting," and then goes about their day without making a single phone call. Start by visiting ssa.gov and creating or logging into your Social Security account to verify your current benefit information and check for any pending actions required on your account. Then call 1-800-Medicare to speak with a representative about how the prescription drug pricing changes and out-of-pocket cap affect your specific plan and medications. Schedule an appointment with your State Health Insurance Assistance Program counselor, known as SHIP. This is a free, completely unbiased service available in every single state. These counselors are trained specifically to walk you through exactly these kinds of changes and help you determine what you are entitled to based on your individual situation. They are not trying to sell you anything. They have no financial interest in what recommendations they make. They are there purely to help seniors navigate the system. And listen carefully, because this is critically important. Be extremely cautious of anyone reaching out to you claiming to help you apply for new benefits related to this Supreme Court ruling and asking for money or personal information up front. Within days of any major legal or legislative development affecting seniors, scammers are already crafting pitches designed to exploit it. They are calling seniors right now telling them they need to pay a processing fee to receive their new benefits. They are sending emails claiming to be from Medicare or the Social Security Administration, asking seniors to verify their account details. They are building fake websites that look like official government portals designed to steal personal information. Legitimate government services are always free. The Social Security Administration will never call you demanding immediate action or payment. Medicare will never ask for your credit card number over the phone. If anything feels off, hang up. Close the browser and call the official number directly from the official government website. The sophistication of senior-targeted scams has increased dramatically in 2026. Scammers now use artificial intelligence to mimic the voices of government officials. They use information from data breaches to make their calls seem more credible by referencing your real name, your address, and partial account numbers. The only protection is skepticism. If you did not initiate the contact, do not provide personal information. Full stop. Now let us bring this home with some honest reflection, because this ruling is about more than legal decisions and benefit adjustments. Think about your own life. Think about the moments when the system felt like it was not built for you. Snorts. Maybe it was standing at the pharmacy counter, choosing which prescription to skip this month because you could not afford all of them. Maybe it was watching a parent suffer in an understaffed facility and feeling helpless to do anything about it. Maybe it was that sinking feeling when you realized someone had stolen from your account and you did not know how it happened or who to call. Maybe it was sitting alone on a Tuesday afternoon wondering if anyone in Washington even knew you existed, let alone cared about your struggles. This Supreme Court ruling is not a magic solution. No court decision, no matter how sweeping, can fix everything that needs to be fixed for aging Americans in this country. But what this 8-1 decision represents is a constitutional firewall around the most important protections that older Americans have fought hard to secure. When 8 justices agree on something, that is not a close call. That is a statement. And the statement this court made is that the legal protections established for older Americans in the Elder Care Protection Act are not optional. They are not subject to being quietly dismantled by industry lobbying. They are constitutionally grounded and legally enforceable. Share this video with every senior you care about, because this is exactly the kind of information that changes lives when it reaches the right people before deadlines pass. The benefits exist. The protections are constitutional. The only thing standing between you and what you are entitled to is the knowledge to ask for it and the action to go get